thank you for joining me today for Real Estate, Religion, and You. My name is Dr. Sylvia Black, licensed real estate broker with affordable homes and apartments. I'm licensed to preach and ordained as a minister, and I have my master's degree in sacred theological divinity. And I'd like to thank you for joining me today for Real Estate, Religion, and You, which is every Wednesday, right here on Time Warner Public Access TV Channel 20, Wednesdays 6:30 to 7 p.m. and Saturdays from 12:30 to 1 in the afternoon. And I'd like to thank you for joining me today for Real Estate, Religion, and You. Now today I'd like to talk to you on a continued basis of my book, Tenants' Rights versus Slumlords Win in Housing Court. And basically, thank you. This book was actually rewritten from a book that I had wrote a couple of years ago. And so this is like the second edition, but I changed the name. It was originally called Fundamentals of Housing and Community Strategies, Volume 1 or 2, I don't remember. And the other volume was Fundamentals of Real Estate and Investment Strategies. And I wrote them when I was originally in New York, before Clinton moved to Harlem, when tenement buildings, brownstones as they're called, were considered an eyesore. And I was able to sell a number of copies, and that turned things around. That changed a whole lot of situations. It made it very, very difficult for you to now look at a building as an eyesore. Now they're looking at it as an investment. So I want to thank you again for joining me today for Real Estate, Religion, and You. And today we're going to continue and talk about this book here, Tenants' Rights. Tenants' Rights versus Slumlords Win in Housing Court. And originally, the reason why the book was written in the first place was basically because this book tells you how to form a tenants association. Okay, it's not just written for people living in large apartment buildings, more than 6 units or more than 5 units, but it's also for individuals if you're renting a single family house. The very similar rights should apply. We all have the same basic rights. Okay, and the basic rights are that, first of all, you have to be served with a 3-day notice if they want to evict you. They have to give you with a petition for non-payment if they're suing you for non-payment of rent. If they want you out for general reasons, they would have to sue you for a holdover notice, and that means that they would automatically have to give you time, and that has nothing to do with the fact that you owe any rent or not. It means that now they want their cousins or their nieces or their children to move into the apartment that you now occupy. A lot of times the landlord can use that as an excuse and say, we're going to file a holdover petition, when in reality they want you out, period, and they have no legitimate excuse. Well, you can definitely fight that, and you can just keep dragging it on and on and on in court. Okay? When the landlord, first of all, when you file with the 3-day notice has to come first. Okay, and you're usually supposed to be given the full 3 days. Okay, which means that the petition for non-payment cannot be filed until on that 4th day. Okay, if the date of the petition for non-payment is any time before those 3 days are up or prior to you having even received the 3-day notice, then you can ask the judge for a dismissal based on improper service. Or you can let the process go through, let the judge grant the owner possession, and then go back to court and file an order to show cause, saying that you would bring it because the judge or the owner had filed it based on improper service. As you can see, here's the 3-day notice, and it's dated after the petition for non-payment was received. Now, I used to call it a dispossess. I don't know, a lot of people don't understand what you mean when you say dispossess, so I just refer to it as a petition for non-payment. Okay, and then once the petition for non-payment is received, sometimes their lawyer will show up. Okay, and they'll call your name and whatnot, and they'll try to work out a payment arrangement with you without you having to sit and wait to talk to the judge. But in certain cases, it will be important that you actually talk to the judge. Sometimes there are actually lawyers from the Legal Aid Bureau that are actually there that could possibly help you with your case. You tell them what you want, and then they will perhaps go ahead and give you, the help that you need, maybe. Based on income, I believe it is, and based on availability. Sometimes it's important for you to talk directly to the judge, but the judge will not listen to you unless you have money or unless you're asking for a petition for non-payment. Now, if you go to court and you just go ahead and let the process go through, then you go back to court and say, look, I would like to in order to show cause based on improper service. So that gives you now more time. Come back to court, have the case heard if you're trying to buy time. Or you can ask for 30 days originally just to get out. You know, a verbal contract is a legal contract. Just keep that in mind. This book is available on lulu.com and also createspace.com. And I have a website that you'll be able to order it from, which I'll give to you soon. And yes, you can go to court and take care of this book. Now, I wrote this basically out of this book. I wrote because I was a 7A administrator. I was in New York City and I'd taken a course. I was living in a building. It had about 4 or 5 buildings to it. I think maybe about a lot of apartments. It had a lot of apartments. And I was living, it was sort of like, it was in the non-African American neighborhood, they would call it a cul-de-sac. But in the African American neighborhood, they call it a dead end, okay? There's only one way in and one way out, you know, sort of like a roach motel, you know. Roaches check in, but you'd be lucky if you check out, okay? And so, cut. Uncut. Okay, and basically I was a 7A administrator, which is a court-appointed building manager. And what happened was I would locate buildings that were run down, and there were a lot of them in New York City and the Bronx. And there were a lot of rundown buildings in the city at that time. Okay, and okay, there's a lot of rundown buildings in the city at the time that I was there when I was, and so there were plenty. What I would do is I'd go in and talk to the tenants, tell them how I could help them organize the tenants into a tenants association, which I talk about in here, tell you how to organize a tenants association right in this book. And also basically to show you how to take your landlord to court and sue your landlord. Okay, so we're going to talk about a few of these things here. I know some of the things may appear to be a little repetitive, but you can always get a copy of the book. And the last 10 or 12 pages or so in this book, I have sample forms. So I have the copies of the forms that you would need, which you should go to court and get the copy that they have there, depending on what state you're in and which county. Okay, because they may or may not have the same type of, you know, it may be a different, like New York City may have a different form than New York, West New York, and you know, it's variable. Now just remember that you as a tenant have a right to live in a peaceable neighborhood. And today we're going to be talking about uninhabitable buildings, or what to do when your landlord doesn't make repairs. Okay? What to do when your landlord does not make repairs. Okay? Now, as I talked about last week, a housing code violation is basically a condition in the building in which you live where it's a danger to your life, health, or safety. A housing code violation can include anything but not limited to, depending on what state you live in, holes in the walls, lead-based paint issues, rodents, lack of heat, hot water, no electricity, broken windows, peeling paint, linoleum, lead-based paint could be another issue. Now, the buildings department, there is one in every state and every county. Okay, usually it's county run, so if you live in like Erie County, you would go to the Erie County Buildings Department. If you live in Cattaraugus County, you go to Cattaraugus County Building Department. If you live in New York, go to whatever county you live in, Bronx, Brooklyn, Queens. Okay? Now, in New York City, the Department of Buildings violation is a notice that a property is not in compliance with some provision of applicable law and includes an order from the Commissioner of the Department of Buildings to correct the violation condition. Okay, the violation is entered against the property in the Department of Buildings information system and must be corrected before a new amendment certificate of occupancy can be obtained. So that could mean that the tenants may have to vacate the building and the landlord will be assessed fines. Okay, so once you file a complaint against your landlord, let's say that the landlord's not making repairs, and you file a complaint against your landlord, okay, and the inspection department, Department of Health, they come out, okay, and they check the building, and they find out, yes, indeed, there are violations in this building, and they are a danger to your life, health, and safety. They will then, perhaps maybe at their discretion, issue fines. Now, the Department of Violations does not carry a fine or penalty itself. However, it can be used as a basis for criminal court summons and prosecution. Now, as I said before, when you rent an apartment from a landlord, the landlord is agreeing and saying, hey, I agree to rent you an apartment that's habitable, that's going to not endanger your life, health, or safety, or your family's life, health, or safety. This is what I'm agreeing to when this lease that you sign, or even if it's not a lease, it's a verbal lease. A contract can be, a verbal contract is just as good as a written contract. If the landlord agrees to a term or something, if they say, you know, if you move into a building, for example, and the rent, you notice in the ad it says the rent is $600 a month. This happened to a friend of mine. The ad said $600, but when they got there, they said, okay, he only had $200. So she said you can pay $200 every 2 weeks, right? And she accepted that for 2 years. So that constituted a legal agreement even before the 2 years was up. So that was a legal agreement between him and the landlord saying your rent is $200 every 2 weeks. After 2 years, then she's filing a paper against him saying he owes a large amount of money, which he knows he can't come up with. And I went with him to court, and I told him their lawyer pulled him aside and talked to him, and I said to him, that's a legal binding contract. She agreed that every 2 weeks he could pay $200. And so he said, okay, we'll give you 30 days, we'll give you 30 days. You know, he said, and who are you? You know, I said, I'm a friend, you know what I mean? So, anyway, the Department of Buildings, or the health department in this case, possibly. Now, an unsafe building, basically, an unsafe building structure is a structure or part of a structure or premises that is a danger to public safety. Okay? When you walk in, I mean, you can look at a building and pretty much tell, you know, if it's unsafe or not. Okay? Now, what to do when your landlord does not make repairs? Well, first of all, like I said before, you take pictures of all the violations, you report them to the health department, and you let the health department know that these, violations are indeed, okay? There are different type classifications of violations, okay, which I wasn't aware of either. Okay, examples of a Class A non-hazardous violation is, like no peephole in the entrance door dwelling. You know, they're still violations, but they're non-hazardous. Improper seat for the water closet. Examples of Class C immediate hazardous are considered as rodents, no heat or hot water, defective plaster. Okay, the classifications are Class A, B, and C violations depending upon the hazard and of the condition. Now, the judge is not informed of these violations. If the judge is not informed of these violations, they are not made aware of public knowledge or public record. No action can be taken against the landlord. So there's several ways that you can contact the landlord. You can send a letter directly to the courthouse with the captioning at the top, you know, where it has your name and the landlord's name and the date and the index number. And you send a letter to the court and any paperwork that you have before the court date, or you can go to the court and say, I'd like to file this with the paperwork so that the judge can look this over before we go to court. And you have the pictures that you've taken, a list of the violation reports that the health department will have given you, and any other records, any agreements, anything at all, and you will bring that with you to court. Okay, and bring it with you and send it to the judge so that he have a chance to look it over. Okay. Now, if the landlord doesn't make repairs, you can sue your landlord just like your landlord can sue you, and I don't know if you knew that or not. But remember that your landlord cannot evict you without terminating the tenancy legally. He cannot change the lock. If he does, that's illegal, and you can not only sue him in court to get the lock off and get back in your apartment, but then you can also sue him in civil court for punitive damages. That's like punishing him for doing something wrong. He committed an illegal act. That's illegal. That's just as illegal as selling drugs on the corner. You're not going to get away with that. They can't get away with what they did. You're going to be held accountable for your actions as well. Okay, the landlord cannot change your lock. The landlord cannot harass you. If he does, then you need to call the cops. Okay, and next week we're going to talk a little bit about rent abatements and stuff. Okay, but if your landlord, like I said, you can take your landlord to court just like he can take you to court. Now, an HP proceeding is when you take your landlord to court. Now, if the city has already issued a violation to the landlord and nothing has been done about it, or the landlord hasn't even done or responded to it, then you can also sue the city as well as the landlord in what is called an HP proceeding. Okay, HP. You can also look up the classification online or in person at the building department in your state. An HP proceeding is a lawsuit that you bring in housing court against your landlord for failing to comply with the law to provide you with a habitable place to live. Habitable means livable. That's not going to be a danger to your life, health, or safety, or to your family's life, health, or safety. That means it's going to be clean and sanitary. How you keep it after you move in is a different story. Okay, that means that he will provide you with a habitable place to live. That is what he's agreeing to when he has you sign that lease. Okay, and you can bring your case against the city for its failure to enforce the law, especially if you reported it to the health department. Okay, now we're talking about civil action. That means money damages. You know, maybe even in Supreme Court you can sue. Or you can sue your landlord and then you sue your city in two separate cases. Or if you sue them together, you know, you could sue them together in small claims court, or you could sue them in Supreme Court, or just civil court. You can go to civil court and sue them. Okay, now you can bring the case against the city for its failure to enforce, to make the landlord make repairs. And by rights, you have all rights to do that. Or for failure to ensure that the landlord has made repairs. Okay, the city, yes, has a responsibility as well, especially if they've been informed. But if you don't tell nobody but Junebug and Bubbingham, then the city can't do nothing about it, and the landlord can't do anything about it. So don't be afraid to talk to the landlord. If you're too scared, take somebody with you, or send him a letter. Text him. I'm sure to get texts. You know, find some way to get some information over to him. If you're too scared to go in front of him face to face, find a way to get the information to him. Okay? And sometimes the landlord is willing to make repairs. Sometimes they don't know that there's repairs that's needed. But it's important that the landlord be notified first before you begin to crucify him. And if he decides, hey, I'm not doing nothing give me the rent and I'll do it. You give him the rent and he don't do it, now it's time to take the next step. Okay? In some cases, you will not need a lawyer. Okay, a lot of times you can do this on your own. The papers are right on the wall, they're hanging up. And sometimes the clerk will give you advice. But I suggest you look it up on the internet, and that would help you be able to distinguish exactly what you need to know so that they're not steering you wrong. You may or may not need a lawyer. You can choose to get a legal aid if you qualify. It always helps to have a lawyer with you, you know. But usually the proper paperwork, like I said, is in court, and all you have to do is fill out the blanks and then file the paperwork with the court. Now, if you don't have any money, you can file as a poor person or as an indigent. It doesn't mean that you're an indigent or a poor person. It just means that this is the classification so that you can avoid the fees in court. Okay? Now, remember to submit the pictures, copies of the pictures. Don't submit your originals. And these Android phones are great nowadays so that you can do almost anything. You can take videos with it. You can record a conversation with it. You can take pictures with it. You know what I mean? So these Android phones are great in terms of collecting evidence. Okay? Now, you get the pictures you choose, everything that's wrong, any reports that you've contacted the health department with, any of their forms that they have, you know, you can't sue the city unless you contacted them first, and they've had ability to do nothing. Okay, now when the case does come to court, the attorneys for the city will prosecute the case for you and force the landlord to make the repairs, and the inspector confirms about all the violations. Okay? Like I said, you can also sue in civil court for money damages. Now, the landlord will either ask for an adjournment to get more time to make the repairs before the case is heard. They may ask, and that doesn't always mean that it will be given. Okay, they may or may not ask. Okay, the landlord could ask for an adjournment sometimes, and sometimes the judge may or may not grant the adjournment. You can object to the landlord asking for an adjournment. Because you can say the landlord has plenty of time to fix these repairs. I contacted this landlord 2 months ago, or 3 months ago, 6 months ago, wherever it was, and I also contacted the city. The city was also notified. They submitted paperwork. They contacted the landlord. He's had plenty of opportunity to fix it. I object to the adjournment. You can object to the adjournment. So you have to learn how to be your own lawyer sometimes. You know, you can't represent nobody else, but you can represent yourself to the hilt, maybe like I've been doing. Okay, the judge may or may not grant the adjournment, but you can have the opportunity to object. Okay, any party signing the stipulation of a settlement, if there's a settlement, a stipulation will usually be signed. It may require that the landlord make the repairs either immediately for Class C violations, or within 30 days for Class B violations, or within 90 days for Class A violations. Fines can be significant for the landlord if the landlord does not make the necessary repairs when they are supposed to make them. And how are they going to find out that the landlord did not make the repairs? You are going to be the one to tell them. You're going to go back to court and you're going to file an order to show cause. And what's the reason for the order to show cause? Is going to be the same index number that you had when you just went to court. So make sure you save all your paperwork. Don't throw anything away, not even the envelope. Save the envelope because the envelope will have the postmark date on it. And that can be used as evidence too in terms of the proper service that they are supposed to file. Like they're supposed to give you 3 full days, 72 hours, in order to make the payment first. You can't file a petition for non-payment on the 10th of June, and you give me the 3-day notice on June 13th. Okay, so that means you didn't give me my 3-day notice. So I'm going to either let the case go through, let the judge grant the eviction, and then go back and file an order to show cause because the landlord failed to provide proper service. Okay, and yes, you do have a defense. Even if you're trying to buy some time because you don't have the money right now, that's a great way to do that. Just keep delaying it and delaying it and delaying it, and there's nothing that they can do about it. But you have to be proactive about it. You're gonna have to keep going back to court. You know. Now the court will enforce fines not only with a money judgment, also the landlord. But if the landlord persistently fails to make the repairs, the court may punish the landlord for contempt, may even lock him up. Okay, and or the building could be taken away from the landlord by the city, and that's what this book is really all about. How to have your landlord removed from active management of his or her own building, have the tenants take over the active management of the building, okay, bring the building up to code compliance with the help of the city, and purchase the building as a tenant-owned low-income co-op. Okay? Landlord, you didn't do what you were supposed to do. You had plenty of time to do it. Now we taking the building from you, and all of this is perfectly legal. Okay, they call it different things in different states. Okay, in New York City they call it 7A administrator. I was a 7A administrator. Okay, in New Jersey they call it the Marini Act. Okay, so you know they may call it different things. But sometimes, especially if the building is uninhabitable, you know, you can sue your landlord even after you move out. That, you know, I lived in your building for X amount of years or whatever, and, you know, the city ended up taking over the building. And so I'm suing you because I was living in an uninhabitable premises. Okay, now once the building is brought back up to code compliance, like I said, the city can either sell the building back to the landlord or continue to manage the property or take some other action. Okay, now if tenants association, you form a tenants association, and I'll talk to you about how to do that on one of the episodes. The landlord has to prove that you have broken the terms of the lease, or he has to prove that you have no money. If you have the money to pay the back rent, the landlord has to accept the money and allow you to continue to stay there. The landlord cannot collect the rent and then put you out anyway. That's illegal. That's called an illegal eviction also. And not only can you regain access to your premises by going back to court, filing an order to show cause, getting them to bring your things back in the apartment, which happened to me in New York in the Bronx. I paid my rent to the judge in court, and I came home from work the next day, and my lock was changed. Okay, luckily my aunt was living in the same building. I was able to stay with her that night. I went back to court the next day, filed an order to show cause for an illegal eviction. I was able to get back into my house. They was forced to, put my things back in the premises. That was a victory. Then I took them to civil court and sued them. It's called punitive damages, and P stands for punishment. I'm punishing you for breaking the law. So you just gave me maybe five, whatever the minimum is, not the maximum. You just gave me $10,000 in your pocket for that stupidity act that you did. You know. Now, state laws have been detailed requirements for landlords who want to end the tenancy. Okay, like I said, it's a petition for non-payment that must be filed after you get the 3-day notice, and you're required to get the full 3 days. Okay. If the landlord doesn't do his property, you can ask the judge for a dismissal on the basis of improper service, like I said earlier. Then you have to prove to the judge that the landlord served you improperly. That's why I say keep the envelopes, because the envelopes will have the postmark date on it. Okay, there was somebody that I know, they got an envelope, and it said June 8th on it, and then it said return for postage. So that means that it would have taken at least 2 days. First of all, they had to return it on the 8th for postage. So that means at least a day had to go by for that. Okay, and then you don't count the weekends or holidays, remember. So if you get a 3-day notice on Friday, you don't count Saturday or Sunday. You start with Monday, Tuesday, Wednesday, I believe. Or either that day is that Friday could be considered a 1 day. But by no means are they required to file the paperwork prior to at least that, let's see here. So if I have to check it out, and I'm not sure. If you know the answer, email me, sblack3001@gmail.com. But I'm not sure if that Friday constitutes the first day. I don't believe it does, but it may. And if it does, that means that Friday is 1 day, then that Monday is the second day, and that Tuesday is the third day. And the landlord cannot file the papers until that Wednesday. So it has to be dated for Wednesday, and then that means you're giving at least 2 weeks or a month or however long the court date is going to take. Okay? Now, in this case, there was a friend of mine, they got the letter that said June 8th, and it was postmarked, said return for postage, and then it was returned. The person, they said they got it, I think, on the 13th, the 13th. They received it on the 13th, so that means that they had, I don't know, they received it the 13th, 12th, 11th. They received it on the 10th. Okay, so that means that they had 3 days. The petition for non-payment was dated June 10th. Okay, it was dated for June 10th. You can't do that because the postmark says June 8th that was returned for postage. So that means that if I didn't get it until June 10th, you know, that means that I had until 3 days later to come up with the rent. And you got to give me my 3 days. That's the purpose of the 3-day notice. Not to let you know you have 3 days to get out, but you have 3 days to do whatever it is that you want to do. You can get out in 3 days, but you have to give me those 3 days. Okay? If the landlord is smart, he will process the papers for your eviction If the landlord is smart, he will process the papers for your eviction all over again once you get this dismissal. Okay, once you get the dismissal, it doesn't mean that you're in the clear. It just means that you've delayed it a bit. You know, now you have more time to come up with the money. The landlord is smart, he will process the papers for your eviction all over again. Okay, just to ensure that, you know, now you actually, you know, give the money like you're supposed to. But this time he has the right otherwise and can keep asking for dismissal. This time he has to do it right. Otherwise, you can keep asking for a dismissal, and the landlord will keep spending money for doing it. All right? You can text your landlord and ask him, how much do I owe? Can I pay you this amount of money on this day here, and then pay you the rest on X amount of day? And he says, yes. That's an agreement. So take that phone with you to court and show the judge that you have this text. Your Honor, I texted my landlord, and my landlord texted me back and said I had until X amount of days to pay the rent, or this is the only amount of money that I had to pay, because he said it right here. And that's a contract. A text is a contract. An email is a contract, baby. Technology is a wonderful thing nowadays. Okay? Technology is a wonderful thing. Now, when you are being sued in housing court by the landlord for the first time, it can be a scary experience. I can agree with you on that. But it shouldn't be. You know, even contacting the landlord, even if it's anal retentive, as I call it, it still can be a little scary because you're not familiar with your rights. Well, there are a lot of tenant activists, which I am. There are a lot of housing counseling agencies that you can contact for free. There's legal aid that you can contact, you know what I mean? You know, and there's just a whole bunch of different things that you can do to basically get some help or get some answers. You know what I mean? But the main thing you have to do is make sure you go to court. You have to go to court no matter what. Please don't miss that court date. You know what I mean? You have to go to court because your apartment, you know, you don't want to get put up. So today I've been talking about what happens if the landlord doesn't make repairs. And yes, the landlord can be fined. Okay, the landlord can be fined, but you can't be just talking to Junebug and bumping them. You got to tell the city, and you got to give the landlord an opportunity to fix it. And I wouldn't give him no 30 days. I would say you have 7 days. You have 3 days, just like you give me. You give me 3 days, I'm gonna give you 3 days. You got 3 days to fix this apartment. Otherwise, I'm contacting the Department of Health. Okay, you can send him pictures of the thing so he can know exactly what's wrong with it. You know what I mean? But by law, he's supposed to let you know when he's coming in your apartment. He's supposed to get your permission to come into your apartment. He cannot come into your house without your permission. If he does, that's illegal as well. Okay, and if you have a dog, you can bite him up to pieces. If you have a gun, you can shoot him, and because it's an illegal entry. He's not allowed to come in your premises without your permission. And I don't care who he is. Okay, so today I've been talking about my book, Tenants' Rights versus Slumlords, Win in Housing Court. And we all go through it. Nobody's exempt, from the best of us to the worst of us. We all go through it. But there is help available. Okay, if you're living in crummy conditions, how to take your landlord to court, I've been talking about today. What to do if your landlord doesn't make repairs. That was the topic. So just remember, you can, and I'm going to be talking about tenants association. In other words, how to form a tenants association if you're living in a unit 6 or more. I'll be talking about rent control, rent stabilization, and a few other things that you might want to know about. But you can always get a copy of this right on lulu.com for your perusal. And I'll have a website that'll be available for you, okay, soon. So I just want to thank you for joining me today for Real Estate, Religion, and You. I know going to court can be a scary experience. It is for, no matter how many times you go to court, honey, your heart will be pumping out your chest and you will be like, oh my God, what am I going to do? Because you never know what's going to happen. You know what I mean? And when you put your hand in the hand of the man who steals the water, then you know what's going to happen. You have a better idea. You will have the victory. Okay, claim the victory now in the name of Jesus. We claim the victory. Anybody that's facing housing court, we claim the victory right now in the name of Jesus. And a lot of these landlords, they're just slumlords. Some of them are cheap. Some of them are like that. Some of them just do it because they don't care. And some, you getting my rent money. You take my rent money. You take my rent money. You fix my place. That's the way you're supposed to do it. Don't put it in your pocket and go on vacation. Okay? So anyway, I've been talking about my book, Tenants' Rights, Win in Housing Court, and ask you to join me right here next week on Time Warner Public Access TV Channel 20, Wednesday 6:30 to 7 p.m., and Saturdays from 12:30 to 1 in the afternoon. As I said, I'm a licensed real estate broker with affordable homes and apartments, and you can visit my YouTube address at Affordable Homes and Apartments. You can hit me up on Facebook at Affordable Homes and Apartments. Okay? And I have a website that you can get this book from directly. Ebooks available only through me. Okay? Holla at a sister. I'll see you next week.